Wisdom and Richard Cardy from Burges Salmon, both of whom, having had many years of experience in advising public and private clients on public procurement, and who are kindly going to provide us with an overview of the Act and what it will mean to yourselves. I'd like to just take a minute to refresh or update your awareness of what CECA is and what it does. CECA Southern is just part of the Civil Engineering Contractors Association, a trade body that represents and promotes the interests of over 300 organisations, delivering about 80% of the civil engineering infrastructure delivered in mainland UK. It is made up of 6 English regions, 2 devolved nations, and a national team in Westminster. We engage on your behalf with government and public bodies at a national, subnational and regional level, and with key clients in both the public and private sectors, as well as with cross-industry bodies such as the CLC. We create a window on the wider industry for our CECA members to ensure that their voice is heard. CECA focuses its effort around our 5 core pillars that consider, amongst other things, clients, policy and workload, health, safety and well-being, skills and training, careers, recruitment, sustainability, carbon and social value. We are a members organisation guided by our members and run targeted CECA sector groups. One of these is the CECA Procurement Group that had been engaging with the previous government on the procurement bill as was for many years to try and bring an improvement in public procurement as part of our policy focus. So it is only fitting that under the CECA core pillar of skills and training that we bring you this webinar. Even though the new government has delayed the go live date, we believe that there is still merit in conveying our current awareness around the Procurement Act. If you would like to hear more about the great stuff that CECA Southern, the South West and the wider CECA does, please visit our website and have a look at our weekly updates. The presentation will be recorded for viewing at a later date, and the slides will be made available to all attendees. This recording will be switched off for the question and answer session. Please can I ask you to put your microphones on mute and save any questions until the question and answer session. If you could place them in the chat box as we go through, and we'll pick those up later. And if you have any particular questions that may be a bit longer and you want to ask, please raise your hand during the question and answer session. I'll now thank you for your attendance once again. As I say, it's really good to see you all here today, and I will hand you over to Laura and Richard, who will take you on the next stage of the journey. Thank you.
Thank you very much, Dave. Can I just check that everyone can hear me okay? Yeah, I can see some nods. Good. Good to see so many of you here virtually. Who would have thought that we could get this many of you out of bed for a procurement seminar on a Tuesday morning? So that is good to see the level of interest. Rich and I are here today, as Dave has said, to kind of talk you through the Procurement Act, but very much focusing on the proactive and practical steps that bidders can take over the next few months and beyond to get themselves ready for what really is quite a fundamental shift in the public procurement regime. Just to introduce ourselves briefly, so you know who's going to be talking at you for the next hour. My name's Laura Wisdom. I'm a partner at Burges Salmon. As a firm, we advise across the public and private sector on public procurement for large, complex, politically sensitive infrastructure projects and beyond. We work pretty much across all sectors, and we also advise on bid challenges when things go wrong. So we kind of get to see, you know, the good and bad side of procurement. I'll just let Rich introduce himself briefly.
Thanks, Laura. So, yeah, nice to meet you, everybody. I'm Rich Cardy. I'm a director here in the same team as Laura at Burges Salmon. So, advise on sort of the contentious and non-contentious side of procurement, primarily on the non-contentious side, and have advised on a number of major public sector procurements for a number of different government bodies.
Okay.
That's on. Thanks.
So the way we've structured the next hour is we're basically going to take you on a whistle-stop tour of the whole procurement lifecycle. Now, we are working on the assumption that the vast majority of you, if you are here today, have already had at least some level of engagement with the existing procurement regime. So we're not going to go completely back to basics, but we are going to talk to you about the kind of key changes that we're going to have in the new regime, from planning all the way through to potential challenge. I'm going to start off just with the obvious question of why is there a new Procurement Act and what is it trying to do? I'm not going to go through the whole timetable here, but there's just 2 points to make. The first one is just how lengthy a process it has been to get a new Procurement Act. And the second is that the Procurement Act is a very, very political being, which is really important when you're looking at the changes that have been brought through. So we see there in the first bullet that the reason we've got a new Procurement Act is effectively following Brexit. Very much a feeling that one of the key Brexit dividends that the UK could get was freedom from what it saw to be a kind of stifling and complex EU-based procurement regime. So that's the reason that the government started looking at this, did a significant consultation scheme. And then we look at the final bullet there, and politics has intervened again. So we were expecting to have our new Procurement Act coming into force, well, this month now, 1st of October. So we were expecting it to come into force at the end of this month. As of a couple of weeks ago, the new incoming Labour government has taken the political decision to delay that to February next year. And that is partly because it wants to recast the existing National Procurement Policy Statement to reflect what it considers to be this new government's key procurement objectives over its term. So you can see there it started with politics and it's continuing with politics, and all of the decisions that have been made in terms of the changes really do have their basis in politics. So what is it trying to achieve? And I will just say here that these ticks are not a suggestion that we think that these things have been achieved, but a suggestion that these were certainly the aims. So we're aiming for a simpler and more flexible procurement regime. I think everybody would have had that as their key objective. But then we also have the kind of bit more of a detail. So placing value for money at the heart of the process, you know, what exactly that means, that's quite a broad objective there. Opening up public procurements to new entrants. So, you know, trying to open up the market to SMEs, for example, has been a key objective for a while, but a real emphasis on that. Taking tougher action on underperforming suppliers. We'll probably spend a bit of time on this later on. This is really key, and as bidders, it's a very, very important point for you to be aware of on the changes here. But this goes back to my original point about how political this act is. If you see all of the media attention, for example, over what has been said over the contractors for Grenfell, for example, you'll be able to see the very obvious link between this new Procurement Act and political decisions about where we should be spending taxpayers' money. And the final one there, which again will have a significant impact on both authorities and bidders, embedding transparency throughout the commercial life cycle. So that is a real objective of the Act. And I think we're going to see a huge explosion of new information out once the Act comes into force. So just by way of broad overview, before we delve into the detail, the key kind of visual change for the Procurement Act is that instead of having separate regulations, and I'm sure you'll all have been fed up of hearing these different acronyms being used, but instead of having 4 different sets of regulations for different types of public contracts, we have now got one single Procurement Act which sets out a common framework. It's not quite gone as far as I think the government had hoped it would in terms of standardisation across the sectors. So it still does have specific provisions for utilities, concessions, defence contracts, for example. So it's not quite the easy read of if you're covered, here's your framework. It is still a bit more complex than that. It does make the Act itself is shorter, which was a key objective of the Cabinet Office. Unfortunately, that means that a lot of the detail has been moved to statutory guidance. We have, for example, an intention for there to be 48 pieces of underlying guidance to the Act. So if you were hoping this meant less reading, I'm afraid I'm going to have to disappoint you there. There are also going to be templates and, as I talked about earlier, a national procurement policy statement, which sets out what the government's overall objectives with procurement is. I've said a single UK framework there, but just for anybody kind of working more broadly across the UK, Scotland has taken the decision to have separate legislation. So just to add to a bit of the complexity here, not only are there Welsh and Northern Irish specific provisions within the Act, but Scotland has got its own legislation entirely separately. So as you can see, it's not necessarily starting off with the simplicity that we had perhaps hoped for. This is really a kind of, take home and have a look summary of the key changes. I'm not going to go through this because the key changes that are likely to be relevant for you as bidders will go through in more detail in each stage. But here's just a kind of, snapshot of everything you can expect in terms of the new Act. So I'm going to hand over to Rich, who is going to kick us off by talking about the planning stage of the procurement.
Thank you, Laura. Yeah, so this first section is really just sort of going through the preliminary considerations that would need to be had, primarily by contracting authorities when they're looking to launch a procurement, but it's obviously relevant from the bidding side as well to make sure that you're aware of what they'll be considering, and also that you can hold them to account to a certain degree to make sure that they are following all the steps that they should be. So just to kick off, we've got a few bits of terminology on the slide here. These are new terms that are introduced by the Act, and I think it's fair to say it's a fairly common theme throughout the Act that there have been a lot of changes in terminology from what we might have been familiar with under the existing regimes, not necessarily because that's looking to do something particularly different in practice, but perhaps linking back to what Laura was saying about the sort of the political background to this, wanting to show a break from previous practice, even if in name, rather than there being sort of tangible differences. So a couple of those. So on a covered procurement is the name given to a procurement which is subject to the obligations under the Act. A public contract, as defined up on the screen, is that's the kind of contracts that is being awarded underneath a process that's governed by the Act. So if you're awarding a public contract as defined there, then that's when you need to be looking at what obligations the Act applies to the procurement of that contract. And a contracting authority is a very broad definition of public bodies who are going to be subject to the obligations under the Act. It's worth saying there are a couple of other bits of terminology that you may come into contact with where there are particular sort of subsets of contract that the Act uses. So defence and security contract, for example, where if you fall into that bracket, there may be slight variations that apply in terms of the particular rules that govern the award of those kinds of contracts. We won't go into the great detail of those right now, but it's just worth being aware whenever you come across a procurement under a new Act that the terminology is important and will help you understand what rules apply to it. So it's worth double checking.
One thing I would mention there, just because it will be relevant to you as bidders, is that if you look at the definition of covered procurement and procurement, actually, it's not just the process. So be aware of that specific change of terminology, that a covered procurement is the award, entry into, and management of. So we've seen it's often quite common for people to think that once the competitive procurement process is over, it's done. Procurement rules, we can forget about them. This very much emphasises that is not the case. There are ongoing obligations throughout contract management. So to the extent that you have kind of, different people dealing with your procurement side of things and your contract management side of things, do think about whether there needs to be any more kind of link up to make sure that everyone is aware of what's happening at both stages.
Yeah, absolutely right. Thanks, Laura. So turning to the next slide. The Act introduces the idea of procurement objectives. So these are certain factors, I suppose, that contracting authorities are expected to take into account when they're both designing, administering, and then delivering their procurement activity. Many of you may be familiar with the fact that there were public procurement policy notices, so PPNs, that were issued from time to time by Cabinet Office, which had various bits and pieces that were almost sort of through policy and guidance, expecting that certain factors would need to be had regard to by contracting authorities when they're conducting their procurement activity. This is slightly different in that it's now giving it a sort of legislative basis for these things to be had regard to. As you'll see on the slide, having to have regard to these various factors isn't entirely clear as to what that's going to mean in practice. There is potential, if you're being cynical, that this could turn into a bit of a box ticking exercise where, provided an authority can say, well, yes, we had regards to it, then we decided to do what we were probably planning to do anyway. It may not lead to much of a change in practice, but I think an important consideration from a bidding perspective is that if decisions seem to be being made, or the way that a procurement has been designed is such that it seems to fly in the face of some of these factors and isn't going to have regard for value for money, isn't going to maximize public benefit and so on, or doesn't comply with the National Procurement Policy Statement, then that could be a grounds to raise challenge at a later date if it doesn't appear that the contracting authority has had regard to it correctly. So I think it's worth being aware of these things and to have in mind when you're looking at procurement documentation that's being issued as to whether or not it does seem to align with that, and then be ready to clarify with authorities if it does appear that they haven't taken all of these points into consideration. Final point on the slide at the bottom there, in terms of contracting authorities having to treat suppliers the same. Many of you will be familiar with the existing obligations of sort of core procurement principles, as we often refer to them, of having to have regard to equal treatment and fairness and transparency and proportionality. The way the Act addresses these points is to not quite have them set out in one place in the same way as the existing regulations do, but this is one example of where the equal treatment obligation is reflected in slightly different language. So the requirement to treat suppliers the same unless different treatment is justified, arguably a little bit more flex there in terms of it's not saying that it's an absolute requirement to treat people equally, but there is an expectation that that's the default position unless there's a good justification for some difference in treatment. Let's move on to the next point. So then going on to one of those other principles of transparency, as we've got up on the slide there, the existing public contracts regulations had an explicit requirement to act in a transparent and proportionate manner. Somewhat oddly, you could argue, the Act doesn't have similar explicit requirements to act in that way, but the principle of transparency and in making information available to the public is something that's found embedded throughout the obligations within the Act, primarily in the number of obligations that have been added around publication of information, whether that be publication of contracts that have been awarded, various lengthy notice provisions that have been included that require information about the procurement process and the intentions around the procurement process before you've even started being made public, mean that over time, the aspiration is that there will be a much greater visibility of procurement activity being conducted across the UK. Quite how accessible that information is going to be and how much people will be able to take advantage of that wealth of new information that's being put out there remains to be seen, I think. But I think the aspiration is to almost take a little bit of a sort of open source approach to procurement, where if you've got all the building blocks and all the information around these procurements being published on a regular basis, it means that people don't have to reinvent the wheel and can see what good practice looks like and start to follow those and potentially develop a sort of a best practice approach that can be more consistent across the public sector. As I say, it remains to be seen whether that will actually be what emerges in practice, but we can only hope. Just a couple of practical tips on the bottom of that slide there as well for people to be aware of. As I said, the number of new notices, there are around 18 notices that are required to be issued at different stages in the procurement and in a contract's life cycle, potentially some of those on multiple occasions when it comes to sort of variation notices and what have you, that it's worth looking into the ability to get yourself signed up for notifications around the publication of notices linked to contracts that you're interested in or opportunities you're interested in potentially bidding for. And then there should be what's referred to as the central digital platform, as Laura mentioned earlier, which is meant to be a one-stop shop for all of these notices to be published. So hopefully by the time we're getting closer to the February go live date, we will have a bit more information about how you can sign up to that and how accessible that information is going to be. But it should provide a means of keeping in touch and being notified of a lot of the information that's due to be published by contracting authorities around the different opportunities out there. And to the extent that that information doesn't seem to be published, or it's not clear that notices that have been issued include all the information you were expecting to see to give you an understanding of how the procurement is planning to be run, then again, the recommendation is to clarify early and as frequently as you need to be able to make sure you get that information. Just touching here on preliminary market engagement, I think then one of the trends that we anticipate we may see coming out of the changes introduced by the Procurement Act is a greater push to have preliminary market engagement. And I think that's in part because there is going to be a greater need to front load the thinking around the contracts that are going to be awarded by contracting authorities. I don't think there is quite the same ability to almost publish a contract notice and then start negotiating with bidders to refine requirements and develop an understanding as to what kind of contract the authority wants to issue, in the same way as arguably is done from time to time at the moment. The need to have published all of the details of the contract that you're planning to award at a much earlier stage, and the way in which you plan to evaluate and assess the tenders that you're receiving, means that authorities would be better served by having a much clearer understanding of what they want to do before formally launching the procurement process. So we would anticipate that one of the better ways to do that, by still getting that insight from the market, is by having preliminary market engagement. And aside from the obligations then not to conduct that engagement in a way that gives certain potential bidders an unfair advantage in the subsequent procurement process, there is also an obligation to publish a preliminary market engagement notice setting out either the intention to conduct market engagement, or if market engagement has been conducted without issuing a notice, that would need to be explained and justified in a subsequent tender notice. So either way, it should be more visible as to whether or not any of such engagement has been carried out. And to the extent that it seems the engagement's been carried out without a notice being issued, and that justification for doing so in the tender notice doesn't seem particularly clear or persuasive, again, it's a recommendation would be to clarify early on as to whether or not it seems like that may have placed you at a disadvantage, and the contracting authority may be obliged to take further steps to level that playing field again before moving forward.
This is really key for bidders from a strategic perspective, because we will absolutely guarantee that authorities are going to be using this to test out broader concepts. So they, particularly in more complex procurements, they are going to be using preliminary market engagement to test out potential contract terms, to test what their red lines should be, to test what the market can take. And if you are not visible and involved in that process, you will not have the chance to have what could be quite considerable influence over what authorities are going out with. So if you can take away one practical step from this, it's do take advantage of this engagement, because this will be a key way that authorities will test the market before going out with their requirements.
Sorry. So next point to be flagging up here, linked to what we've just touched on, is that from the 24th of February, when we enter this new world under the Act, one of the most notable changes is likely to be the way in which the different kinds of procurement process that are run are going to be described and worked in practice. So on the left-hand side of the slide, you can see that there are references to restricted procedure, competitive procedure with negotiation, and competitive dialogue. Those are all existing forms of process that can be run for a compliant procurement process under the public contract regulations. Under the Act, these are trimmed down to effectively be you have an open procedure or a competitive flexible procedure. And that latter category is intended to be all-encompassing, really, of all the different kinds of process that could include a restricted procedure or a competitive procedure with negotiation and so on. The idea being that it's giving contracting authorities, subject to certain sort of minimum requirements that must still be met, more flexibility to design a procurement process that best fits the kind of contract that they're looking to award. And I think in practice, it's difficult to tell at this stage how much authorities will be keen to take advantage of that flexibility. I think it's probably a reasonable assumption that at least in the early stages, we'll probably see authorities launch procurements that bear a strong resemblance to the restricted procedure and so on. But it's likely that some of these processes will evolve over time, particularly, as I say, with the amount of visibility that is going to be had for contracting authorities conducting their different processes and having to publish notices describing all of the steps that they're taking. It may be that new ways of working on new kinds of variants on procedures do start to emerge. And I think the key takeaway on that is that we all need to be very careful to be reviewing the invitations to tender and other procurement documentation that are issued at the outset to understand whether there are any particular nuances around the process that are going to be employed by that contracting authority that it's worth being aware of and making sure that you're ready to respond to as the process goes through, rather than being caught out because it doesn't quite match up with what you're expecting. I move on to final slide for me, and I'll come back to Laura. So we've got a bit of detail here around direct awards, which are still another compliant route to be able to award contracts where a ground justifying the direct award applies under the Act. These are now largely set out in a particular schedule, Schedule 5 to the Act, albeit that there are a couple of other specific routes to be able to directly award contracts set out in certain sections of the Act. Couple of ones to pick out here that are more notable. First is the top one there around there being a new power for ministers to allow direct award to protect human, animal or plant life or health or public order or safety. This is something that has really been driven by some of the feedback around the pandemic and the government's response to that, where there is now an ability for a minister to designate a particular category or type of contracts that, for a particular reason, for a particular period of time, ought to be permitted to be directly awarded, linked to one of those grounds listed there in pink. So again, how that will be used in practice probably depends on the willingness of the minister to start designating particular categories of contract that should be able to be directly awarded. I'm sure that they will be subject to very close scrutiny if they do start to use this power a little bit more frequently than we were expecting. But worth being aware of that where that applies, then public authorities will have much more ground to be able to go out and directly award contracts than they would otherwise be expected to. I won't go through all of the other points on the slide, but the other element that I wanted to pick out is just that final bullet point there, in terms of there now being a mandatory obligation in most cases to publish a transparency notice where an authority is looking to directly award a contract. And that notice has to be published before awarding the contract, and then a standstill period needs to be held in a similar way to the end of a competitive procurement process. And the difference here is that under the existing regime, it's not uncommon to see contracts be directly awarded, and then almost there is a notice after the fact to say, this is what we have done from the contracting authority, which inevitably makes it a bit more difficult to get in and query the steps that have been taken if actually you feel that the direct award wasn't justified in that instance. So the idea of having this brought forward is that it gives greater scope for constructive challenge to authorities to be able to say, to question whether or not they were permitted to take the route that they've done, rather than getting to the point where the contract's been awarded and already been entered into, and then challenges are all about looking for potential damages or something of that nature, rather than just being able to stop the process and then potentially require a formal competitive procurement process to be held if that's the right course of action. So on that note, I think I'll pass back to Laura, who's now going to touch on the selection stage.
Thanks, Rich. Yeah, I'm going to talk about selection stage. I mean, it's a bit of a misnomer there because, as Rich has said, with the procedures being kind of more tailored and flexible now, there won't necessarily be what's called a separate selection stage. So I'm sure you'll all be common with kind of the current selection, so the SQ or the pre-qualification questionnaire, PQQ. Instead, we've got a new set of terminology. So our selection questions are now going to be referred to as conditions of participation. And if an authority decides to set those conditions of participation, they will be undoubtedly what you would expect to see. So in relation to financial capacity and technical ability. So they're likely to look quite similar to now. We do seem to have gone kind of slightly up and down in approach on this, because I'm sure many of you will kind of remember the standard selection questionnaire being brought in, because there was very much a view that this process should be more standardized to allow for SMEs, for example, to get used to the process and have a better chance of getting through this stage. We're now actually kind of going the other way, in that we're moving away from standardization. So authorities will be able to set whatever conditions of participation they consider to be appropriate and proportionate. We're not currently expecting that there's going to be a replacement, for example, to the Cabinet Office's standard selection questionnaire. Instead, our current understanding is that the central digital platform, when it's set up, will have basic selection stage questions, mostly aimed about the old mandatory and discretionary exclusions that we'll come on to. So there will be basic information on the central digital platform, but then everything else is likely to be procurement specific. So this is one area where we might perhaps see a bit of change in practice going forward. I think the key point there is the practical step there, that when the central digital platform does come online, do make sure that you and your supply chain are all registered on that and are keeping your details up to date, because the intention is very much for that to be the central repository of this basic information about you as bidders. So it is really important that that information is kept up to date, because authorities will be using that as an active tool to check information on you. Just to mention in relation to that, by the way, that the Cabinet Office guidance, some of you may well be aware, I think CECA actively supports the use of the Common Assurance, the Common Assessment Standard at PQQ or SQ stage. The Cabinet Office guidance has made clear that those sort of standard selection questionnaires can continue to be used, but only if they do comply with the requirements of the new Procurement Act. So I am assuming that all of those standard questionnaires will be going through a process of checking at the moment to make sure that they are compliant. I'll skate over this because it's not really a surprise that conflicts of interest still are something that is kind of a thing that needs to be checked under the Procurement Act. The provisions are not that different from what you would be used to under the existing regime, apart from the fact that, you know, as with everything under here, there's kind of a new notice. So there is a duty on authorities to prepare a conflicts assessment and to keep that up to date throughout a procurement. So from a bidder perspective, not that our advice would really have differed to now, but it's about making sure that you are aware of what your internal processes are for identifying and being able to manage potential conflicts of interest, so that when undoubtedly you get requests for confirmations that you don't have conflicts of interest, you're able to very quickly identify what those conflicts might be and to have systems set up to make sure that you can deal with kind of, you know, any situations where there might be a perceived issue. Do be aware that if you do have prior involvement in a tender, it can potentially put you in a bit of a difficult position in relation to potential conflicts of interest. So if you are involved or considering being involved with an authority in designing a procurement, so kind of any pre-tender work, for example, do make sure that you are asking for assurances from them if you're interested in bidding for the follow-on work. to make sure that you have set yourself up in such a way that you will still be able to bid for that follow-up work. So do just make sure that you're not just thinking about the current work, but also what position is this going to put me in with this authority for the future. I'm going to spend a bit of time on the next couple of steps, which is probably the most important and biggest change in relation to the selection stage. So all of you, I'm sure, will be familiar with the current provisions in relation to mandatory and discretionary exclusions. So those are the grounds on which a bidder can be excluded from a procurement at the moment. So in relation to mandatory, you've got your kind of terrorism and corruption offences and that sort of thing. And then you've got discretionary things which can exclude you from a procurement as well. We still have that principle, and the grounds are not vastly changed under the Procurement Act. But what has changed is very much what the consequences of those might be. And this links into the point I made earlier about how one of the key objectives from the Procurement Act was to make sure that underperforming suppliers can be more easily excluded from having access to public contracts. So importantly, it will not just be checking the exclusion grounds for suppliers, but you should also be aware that if you are bidding for a contract, that you need to make sure that your entire bidding house is in order. So you need to make sure that what the grounds would apply to in relation to associated persons and connected persons. So there are going to be checks in relation to parent companies, subsidiary companies, predecessor companies, persons with direct control over you. And also, importantly, your supply chain. So as much as this is not intended to go all the way through every subcontractor you may have, it's at least going to go down to your tier ones. And it may well go further than that if you are relying on a particular specialist subcontractor, for example, to be able to bid for a procurement. So the key practical step here is get your house in order, make sure you know your supply chain well, make sure that you have processes and policies in place to be aware of any potential grounds for exclusion early throughout your supply chain. And then down in that kind of teal, cyan, not sure what that colour is, but poor performance ground expanded. This was a key concern under the previous Act, that contracting authorities basically were finding it too difficult to exclude poorly performing contractors. So that ground has been expanded. That is really, really important for bidders because the provisions are broad. They are worryingly broad. And coupled with some points that we will come on to in relation to increased monitoring and visibility of contract performance, this really is something that can trip up bidders surprisingly easily. The guidance has obviously made clear that the intention is only for bidders to be excluded where their poor performance is kind of egregious, really significant. But the drafting in the Act doesn't necessarily support that. So there is a ground for exclusion, for example, if you have not performed to a contracting authority satisfaction. So it doesn't have to be the contracting authority that you are bidding for here. So if you perform poorly for one local authority, that could potentially have a knock-on impact for a central government department, for example, and you've been given a proper opportunity to improve and you failed to do so. That doesn't link to any KPIs or anything like that in the drafting. So there is really quite a significant risk area for you there to be aware of. And as you would expect, that also extends to breaches of contract or alleged breaches of contract. So, this really is a ground that could hit you quite hard practically. And that's primarily because if an authority does decide to exclude you from a procurement, we can kick on, they also then have to notify the Cabinet Office, and the Cabinet Office will institute an investigation to determine whether you should be added to a central debarment list. This is a significant change to the previous regime. We have never had a central debarment list before, but this will be a publicly available list of companies that are assumed not to be able to bid for public contracts. Once you get onto the debarment list, you are stuck on there for potentially up to 5 years, depending on the offence. And every authority has to check the debarment list before they allow a bidder to bid. So if you are on there, this really is going to have a significant impact on your ability to bid for public contracts. It's not guaranteed that if an authority excludes you, that the minister will decide to have you added to the debarment list, but there is the real potential that is there. There is a specific challenge regime, as you would expect, in relation to this. So it is really important that you are on the front foot if there is any suggestion that you might be getting anywhere near this sort of territory, because obviously it could have a huge impact on your business.
I was just going to add as well, I think just linking to that in terms of there being a specific challenge regime, I think it's worth saying as well that the grounds to be able to challenge a decision to be added to the debarment list once that's happened are pretty limited. So really the recommendation is going to be that before it gets to that stage, you want to be making it as clear as possible that you don't feel that it's appropriate to have met the grounds to require a notification to Cabinet Office, or to be making sure that you're actively participating and cooperating with the investigation to demonstrate that there isn't a good basis to be putting you onto that debarment list before it happens. Because if you're only looking to sort of challenge it after you're on there, really the opportunity to deal with a lot more of the sort of the factual basis for any circumstances that may have led to the reason are a lot more limited. It's really whether or not the minister has misapplied themselves in law, which is going to be a much more challenging thing to try and question.
So I've put some practical tips up on the next slide, which you can read in your own time. I think the only thing to kind of really emphasize to you here is that this also applies throughout your supply chain. So not only do you need to have processes set up to make sure that you are aware of potential risk areas across your contract portfolio, but you also need to be aware of anything in your key subcontractors for anything. So you do need to be aware and have processes for potentially swapping out subcontractors if there is a risk that they might drag you into this regime, for example. So I'm going to hand back over to Rich. He's going to talk about the award stage.
Thank you, Laura. So yeah, few points to pick up again, just in terms of terminology. Many of you will have been aware of the reference to meat. Vegetarians will be pleased to hear that that's not going to be appearing in procurement documentation quite as frequently as before now. We've got a reference to MAT instead, which is the most advantageous tender rather than the most economically advantageous tender. Practically, it's unlikely to make massive difference to how award criteria are developed and put into place, but it does demonstrate an intention to mean that it's not necessarily going to be all about price. There is much more of a sort of tacit approval of the ability to put a reasonable weighting on the technical or other performance requirements, as opposed to just putting it all on price from a weighting perspective. And in terms of how those criteria are developed, there is an expectation under the Act that to be the most advantageous tender, that response needs to have satisfied the authority's requirements as described in the tender notice and associated tender documents, and then best satisfy the award criteria when assessed by reference to the methodology detailed in those procurement documents. Point to note on that is that there is an expectation that you can't be the most advantageous tender unless you've satisfied the authority's requirements. So that could create a few wrinkles in practice if it turns out that actually the bidder that scored highest against the award criteria doesn't technically meet all of the requirements as they've been set out in the document. So you could see how that could then create questions being asked by other bidders who may meet all the requirements but not score as highly, in terms of saying, well, they're not permitted to be the most advantageous tender, so award the contract to me instead, please. Again, one of those things that will probably get worked out in practice, but it's a nuance created by the difference in terminology that we're not quite sure was intentional. In terms of some practical steps, a lot of these are going to be very familiar to those of you that are participating in regulated procurement processes at the moment. As I've mentioned in the previous section, it's really important that tender notices and procurement documentation are reviewed really carefully when they're issued. If there is anything that is unclear or doesn't seem to include the information that you would have expected to see, issue clarifications as early as possible to try and get that information so that you're not placed at a disadvantage or potentially lose the ability through passage of time to be able to question it at a later date. Worth being aware that the authority can still refine their award criteria through the process. There are more limitations on that than exist under the existing regime. So once the deadline for tender submission has passed, for example, it's going to be very difficult for a contracting authority to modify anything that was set out as an award criteria. So if there are any sort of amendments that are made throughout the process, again, worth clarifying if you feel that they are not being conducted in a fair and equal basis. But otherwise, it's probably going to be similar kinds of considerations to those you might have at the moment. One of the points on there notes the requirement to scrutinise proposed KPIs carefully. That's something that we'll come on to talk about a little bit later on as well. But just linking to what Laura's just mentioned around the poor performance ground for exclusion of potential debarment, there are requirements for contracting authorities to set and publish details of certain KPIs under their contracts. And that's obviously going to be one of the most visible ways of assessing whether or not a contractor seems to be performing to the required standard, because the KPI is implicitly setting out what the standard ought to be in terms of good delivery of the contract. So if you are not comfortable that the KPIs being set are fair or appropriate or realistic, then it's worth challenging those at an earlier stage, because once those have got locked into the contract, poor performance against them could really come back to bite you at a later date, even if actually from a practical perspective you consider to be delivering everything that the core thrust of the contract is expecting you to deliver. And then last point on there, just in terms of links to these additional notification requirements and publication requirements, it's really worth making clear where aspects of your tender response are commercially sensitive, or where you would be uncomfortable or don't or want to try and prohibit publication of certain of that information. It's not going to be acceptable to the contracting authority to see people who just mark their whole response as being commercially sensitive. They will come back and say, well, no, that can't be right. Tell us which bits are the really commercially sensitive ones. But it's worth doing that properly and to market where there's the opportunity to do so, because it can avoid information being inadvertently shared with the market that you would be uncomfortable happening. And then in terms of award decisions themselves, there is a slightly different ordering to the process to what you might have expected to see before. So there's still the idea of an award notice being published to the market, but now before that happens, an assessment summary, which is what we might have previously associated with a debrief letter or a standstill letter being issued to bidders. Those have to go out to bidders. Then the contract award notice is published, and it's that public notice which starts the standstill period off, rather than the publication of any standstill letters or debrief letters. And there's then an 8 working day time period for the standstill period to run, during which the contracting authority is not permitted to enter into the contract. That eight working day period is different to the 10 calendar day periods that exist under the current regime. So not a massive difference in practice there, but hopefully it will mean that fewer contracting authorities plan to issue contract award notices just before Christmas to take advantage of the fact that there are a load of bank holidays, which actually mean that there are very few days for a bidder to be able to get themselves organised to challenge during that time. Now that won't be quite as easy for people to do. So yeah, I think, as I say, just be aware of the fact that it's contract award notices that start that standstill period, and that change to being an 8 working day period as opposed to 10 calendar days. Final bit from me on this section is just to touch a little bit more on those assessment summaries. So this slide sets out the detail of what needs to go into those assessment summaries. Full details of that are set out in both the Act and in subsequent regulations, and I think it's fair to say there's quite a lot of detail that's going to need to go in there. So you'll probably find that contracting authorities design the response requirements under their procurement documentation in a way that will help them be able to include all the necessary information that they need to put in those debriefs when it comes to it. I think helpfully, from a bidder perspective, we're hoping that there will be a bit more standardized approach to making sure that debrief information properly articulates why a particular score was awarded by reference to both the bid that was submitted and the award criteria set out in the tender. Whilst that's always been good practice under the current regime, it's not been something that has always happened, and contracting authorities haven't always given good justifications for the scores that have been awarded. Now it's much more explicitly required that if the justification for a particular score doesn't have regard to or make reference to relevant bits of the tender response, then that's not going to meet the requirement. So again, if you feel like you've received an assessment summary that doesn't do that, doesn't give you that visibility of how your tender was scored and why you received particular scores, clarify early and question that, because that is information to which you will likely be entitled. Final point just to note on that, again, because this information is being published both in assessment summaries to individual tenderers, but also a lot of it's going to go into the contract award notice issued to the public at large. Now, for procurements with a value over 5 million, there is an obligation for the authority to name unsuccessful bidders as well as just the successful provider. So again, there's just going to be more visibility of procurement activity in general. And again, if there is anything you don't want to have published in any of those information and any of those notices, please do mark it as commercially sensitive and make sure you understand before things are being submitted what might ultimately be made public at a later date. And back to Laura.
Yeah, so as I said at the outset, it's been made specifically clear now that the procurement obligations extend fully into the contract management period. So I'm just going to cover the kind of three main ways in which that is going to be relevant for you if you are successful in being awarded a public regulated contract. So the first is in relation to contract performance. We've talked about this a number of times already, but effectively the key obligation is that if you are being awarded a contract that's got an estimated value of above 5 million, the authority will, in almost all cases, have to set and publish KPIs in relation to that contract. And it will then have to report performance against those KPIs on a 12-month cycle. So that's the point that we've made plenty of times, that because of the obvious link through to the poor performance category leading to potential exclusion and debarment, this is a key area that you need to be comfortable with if you are entering into one of those contracts, because your performance against those KPIs for many contracts is going to be publicly available. And the authority will also have to issue a contract performance notice in these specific poor performance circumstances. So if there is a breach, or if the authority considers that the supplier isn't performing to its satisfaction. So, you know, there are some really specific transparency obligations in relation to both good and poor performance for you to be aware of. The second area where contract management is going to be key, and this will not be a surprise to many of you because this has been an issue under the existing rules as well, but contract modifications remain regulated, not in a dissimilar way to how they are now. So the current position is that basically changes to public contracts are not permitted without a new procurement procedure unless they are specifically permitted. So we had what we used to call kind of safe harbours under the old legislation. They have pretty much been pulled through to the Act with a couple of new ones, but effectively, if your change to the contract does not fall within any of these categories, then there is a risk that it could be challenged. So it's really important that you are aware of these. One of the key ones I think is really important from a bidder perspective is this entirely new ground there that you'll see under the Schedule 8 permitted modifications, which is materialisation of a known risk. So this is intended to basically allow a contracting authority to identify a list of known risks in relation to a contract and it will then, if it meets it jumps through a huge amount of hoops in relation to it, but it will be able to change the contract to deal with that known risk materializing. So that's a circumstance where the risk is known, but the impact and consequences are not known. So potentially this does give quite a significant scope for changing the contract in those circumstances. And that is one area that I would really, really recommend that you're engaging with authorities on in preliminary market engagement, or, you know, just engagement more generally, because if you are aware, because, you know, as bidders, you are the market experts here. If you are aware of risks which really could materialize during this contract, you want to be making the authority aware of them at an early stage so that they can be specifically provided for, because then there is ultimately more of a chance that you might be able to continue to do that work in the future. The key thing that isn't on this slide, which is a key difference from how modifications are generally dealt with now, is that currently there are only a couple of safe harbours that require a notice. You will be unsurprised to hear, based on what we've talked about with transparency throughout this session, that there is a new notice. So in almost all of these cases, the authority will have to issue a notice to the market prior to making the change. So for, you know, significant long-term construction contracts, for example, that could reflect a real change of approach in the future, because if you can imagine how many change notices there might be on a contract like that, a lot of them may well have to be made known to the market. So another reason to be on top of contract performance, contract status, potential for confidential information to be disclosed, all of those things are going to be relevant throughout contracts in relation to these. The last area in which the Procurement Act is going to hit, again, this isn't a significant change from the current regime, but there are a number of implied terms that will be implied into public contracts, and in practice, we do expect them in the majority of public contracts to be made explicit, to be fair, but even if they're not, there are terms that will be implied in relation to payment. So this is all the prompt payment stuff that you will have seen before, and in relation to termination. So there will always be an implied termination right into public contracts where a contract has been awarded in specific circumstances. So they are things that you do need to be aware of, and, you know, they are things to make sure that you are having a look at in the contract provisions to see if they're expressly provided for. We're running out of time, so I will leave that contract management slide to you, but hopefully that is kind of, you know, another few practical steps to be taken. And Rich will finish off just with, I think we just have one quick slide on challenges.
Yeah, that's right. Thank you, Laura. So yes, I think we can hopefully deal with this relatively swiftly. Comes to time and let you get to being able to ask us some questions. The overall process for procurement challenges and the court process hasn't really changed under the new Act. It's likely that there was at some point talk about whether or not a separate procurement tribunal might be set up to try and manage and run procurement challenges in a slightly different way. That's not come to pass. So whilst there is an intention to sort of take other steps in terms of that sort of court process to speed up and simplify the process, ultimately, it's very similar to how it is at the moment. A couple of key changes are that there's a bit of change in terminology. So now the ineffectiveness remedy that many of you have come across before is now referred to as set aside, just to reflect how it would be worked in practice, that you're setting aside the contract rather than making it ineffective. Not really a practical difference between the two, otherwise, aside from terminology. And the test for lifting automatic suspension, so this being where if a contract was planned to be awarded during the standstill period, a challenge has been formally issued, the contracting authorities then automatically injuncted from being able to and prevented from being able to award that contract until the dispute is settled or the suspension is lifted. The test for that has been revised somewhat, and the details there on the slide. It's going into a little bit more detail than we've probably got time to do right now, but it is going to be interesting to see quite how that might amount to a change in practice, because generally it was more straightforward probably for contracting authorities to get suspensions lifted under the current regime. Whether or not that amounts to a change of practice with an intention to try and get things resolved before getting to the point of contract award, we'll wait and see. Otherwise, the fundamental point around challenge remains that this is an area where you need to act quickly, and it's worth being on top of having all the information to hand, having the understanding of the process and what's gone on, and be able to clarify and ask questions quickly, because the time limits are very short to be able to take action. So yeah, it's worth moving quickly if it's something that you feel you may need to do.
But unfortunately, all of the issues you may have found with bid challenges in the previous regime still remain. This is one area that has not changed significantly, which is kind of a real missed opportunity.
Absolutely. One other final point I'll just mention is that there is now the Procurement Review Unit, which has been established within Cabinet Office, which is intended to scrutinise sort of public procurement practices more generally and investigate particular instances where it seems like there's sort of systemic issues. That might be something that you want to refer particular bad practices to if you start to see the same issues emerging from multiple different authorities or the same authority all the time. But that's unlikely to be able to directly change any outcomes or any procurements like that. It's more about being able to draw poor practice to the attention and then for the unit to be able to issue guidance to try and change that. So improving practice more generally rather than being an alternative to legal challenge. On that note, I think
we're 1 minute late. That's not too bad.
Not too bad.
So Lucy, I don't know if you want to turn off the recording and then people can feel free to ask any questions. We've got one from Dave in the chat already.
Yeah. Did you want me to
yeah, do you want to just read it out, Dave?
Yeah, thank you very much for that. I mean, I can see now why it's so important that we did put this event on today, because the implications are quite significant. And one of my biggest concerns is that you mentioned there were 48 pieces of legislation around the Act still to be sorted. There are templates.